I inherited my grandfather's 200-acre ranch in rural Montana just outside of Billings, and 3 months later, a woman named Patricia Brennan showed up at my door with a clipboard and a smile that made my skin crawl. I was fixing a fence post near the main gate when I saw her silver Lexus kicking up dust on the access road. The ranch had been in my family for 4 generations, sitting on prime land with mountain views that stretched for miles. My grandfather, rest his soul, had built this place from nothing, and now it was mine. Nathan Garrett, ranch owner, had a nice ring to it, even if I was still getting used to the responsibility. Patricia stepped out of her car wearing a cream-colored pantsuit that had no business being anywhere near a working ranch. Her blonde hair was pulled back so tight it looked painful, and she carried that clipboard like it was a weapon. "Mr. Garrett?" she called out, not waiting for me to reach her before continuing. "I'm Patricia Brennan, president of the Cascade Hills Homeowners Association. I need to discuss some very serious violations with you." I wiped sweat from my forehead and walked over, confused. "I think you've got the wrong place, madam. This is a private ranch. Has been for decades. There's no HOA out here." Her smile widened, but it didn't reach her eyes. "Actually, that's where you're mistaken. The Cascade Hills community expanded our boundaries last year. Your property now falls within our jurisdiction. We've sent multiple notices to the address on file." "What notices? I just inherited this place from my grandfather 3 months ago." She flipped through papers on her clipboard with manicured nails. "Well, that's not our problem, is it? Regardless, you're in violation of several community standards. That barn needs to be repainted in approved colors. Your livestock pens are visible from the main road, and you have multiple vehicles that appear to be work trucks parked in plain view." I stared at her, genuinely wondering if this was some kind of joke. "This is a cattle ranch. Of course I have work trucks, and that barn has looked like that for 30 years. The community standards require all structures to maintain aesthetic harmony. You have 30 days to comply or will be forced to take action." She handed me a thick packet of papers. "This outlines all the violations and the fines you'll incur if they're not addressed. Have a good day, Mr. Garrett." She turned on her heel and walked back to her Lexus, leaving me standing there holding what had to be 50 pages of nonsense. That evening, I sat at my grandfather's old desk and read through the entire packet. The list was insane. They wanted me to repaint the barn in earth tones from the approved palette, which apparently didn't include the weathered red it had been for decades. They wanted the livestock pens moved farther from the road, or aesthetically screened. They wanted my work trucks parked in an enclosed garage. They even had issues with the fact that I had a dirt driveway instead of paved or decorative gravel. The fines were equally ridiculous, $500 per day for each violation until corrected. By their count, I was looking at over $3,000 a day if I didn't comply. I called my buddy Jake, who owned a ranch about 20 miles north. "You ever heard of this Cascade Hills HOA?" "Oh man, you got hit by them too?" He sounded sympathetic. "Yeah, they've been expanding like crazy. Started as some fancy subdivision about 5 years ago, but they keep redrawing their boundaries. They went after the Hendersons last year, tried to make them tear down a 100-year-old windmill because it was visually disruptive." Can they even do that? Just decide they have authority over private property? That's the thing. Most people don't fight it. They just pay the fines or move. But the Hendersons fought, and from what I heard, they eventually won. You should talk to a lawyer, man, a good one. I spent the next day making calls. Most attorneys I contacted seemed hesitant, saying HOA cases were complicated and could drag on forever. Finally, I got connected with Margaret Chen, a property rights attorney based in Billings, who had a reputation for taking on difficult cases. Her office was in a modest building downtown, but the walls were covered with framed case victories. Margaret was in her 50s, sharp-eyed, with gray streaking through her black hair. She listened to my story without interrupting, occasionally taking notes. "Do you have the original deed to your property?" she asked when I finished. "Yeah, my grandfather kept everything. It goes back to 1947 when his father bought the land." "Good. Bring me all of it. Every deed, every survey, every document related to the property. Also bring me everything this HOA has sent you." She leaned back in her chair. "Nathan, I'm going to be straight with you. What they're doing is aggressive and possibly illegal, but HOAs have a lot of power in Montana if they're properly established. The question is whether they actually have jurisdiction over your property. How can they just claim they do? They can't, not legitimately, but they can file paperwork, redraw boundary maps, and hope nobody challenges them. It's a bullying tactic. They go after properties they think won't fight back. She gave me a serious look. This is going to cost money, and it might take time. Are you prepared for that? I thought about my grandfather, about the 4 generations of Garretts who had worked this land. Yeah, I'm prepared. Over the next 2 weeks, I gathered every document I could find. My grandfather had been meticulous, keeping records of everything. Margaret reviewed it all, and then she started digging into the HOA's own paperwork. Meanwhile, Patricia wasn't letting up. She came by the ranch twice more, each time with new violations. Apparently, my fence posts were the wrong color. My tractor was too visible. I had unauthorized signage because there was an old wooden sign at the entrance that said, Garrett Ranch established 1947. The fines kept piling up on paper. According to their accounting, I now owed them over $40,000. Then came the certified letter. Margaret called me as soon as I sent her a copy. Nathan, you need to come to my office right now. I made the drive in record time. Margaret had the letter spread out on her desk, and she looked angry. They're threatening eminent domain, she said. They're claiming your property is essential for community development and that if you don't comply with their standards or pay the fines, they'll begin proceedings to acquire your land through eminent domain. I felt my stomach drop. Can they do that? No, or at least they shouldn't be able to. Eminent domain is a government power for public use. An HOA is not a government entity, and there's no legitimate public use claim here. She tapped the letter. But this tells me they're either wildly misinformed about their authority or they're deliberately trying to intimidate you into giving up. What do we do? Margaret's eyes glinted. We fight back with case law, and we do it hard. She spent the next several days preparing a response. When she finally showed me what she'd drafted, it was beautiful in its precision. She cited case after case where courts had limited HOA authority, particularly regarding properties that predated the HOA's establishment. She referenced Montana's specific property rights laws. She included detailed analysis of why the HOA's claimed boundary expansion was legally questionable. But the centerpiece was her discussion of eminent domain. She cited Kelo versus City of New London, the Supreme Court case that had clarified limits on eminent domain abuse. She brought up several Montana cases where attempts to use eminent domain for private development had been struck down. She made it crystal clear that an HOA threatening eminent domain was not just wrong, it was potentially actionable. We're not just defending, Margaret explained. We're going on offense. I'm demanding they provide legal basis for their jurisdiction claim, and I'm putting them on notice that if they continue with these threats, we'll pursue legal action against them for harassment and abuse of process. She sent the letter. Then we waited. 3 days later, I got a call from an unknown number. Against my better judgment, I answered. Mr. Garrett, this is Donald Peterson. I'm the attorney for Cascade Hills HOA. His voice was smooth, practiced. I've reviewed the letter from Ms. Chen. I think there's been some misunderstanding here that we can clear up. What misunderstanding would that be? Your property's relationship with our community. We're not trying to be unreasonable here. We simply want to maintain standards that benefit everyone in the area. Property values, you understand. My property predates your HOA by about 60 years. I don't see how you have any authority over it. Well, that's a matter of interpretation. Our boundary expansion was properly filed with the county. We have documentation. He paused. Look, Mr. Garrett, litigation is expensive and time-consuming for everyone. What if we could reach a compromise? You address some of the more significant concerns. We reduce the fines substantially. Everyone moves forward. How about this instead? You acknowledge you have no jurisdiction, drop all fines, and leave me alone. His tone cooled. I don't think you understand the position you're in. We have significant resources and community support. If this goes to court, you'll be facing years of legal battles and mounting costs. Then I guess we'll see each other in court, Mr. Peterson. I hung up and immediately called Margaret to tell her about the conversation. Good, she said. Don't talk to them again without me present. They're testing you, trying to see if you'll crack. The fact that their attorney called directly with a settlement offer tells me they're not as confident as they want you to think. You really think we can win this? Nathan, I've spent the last week buried in property records and case law. Your grandfather's deed is ironclad. The county surveys clearly show your property boundaries haven't changed. And I found something very interesting about the HOA's boundary expansion. What's that? It was never properly approved. Montana law requires HOA boundary changes to be approved by a supermajority of existing members and filed through a specific process with the county. They filed paperwork, yes, but it was incomplete. They didn't follow the proper notification procedures, and based on meeting minutes I obtained through a public records request, they didn't have the required vote percentage. I felt hope surge. So they have no authority at all? That's what I believe, and that's what I'm going to argue. But Nathan, we need to be prepared for this to escalate before it gets better. They're not going to back down easily. She was right. A week later, I found a crew of people walking around my property with surveying equipment. I drove out to meet them. What are you doing on my land? A young guy with a clipboard looked uncomfortable. We're doing a survey for Cascade Hills HOA. We were told we had authorization. You don't. This is private property, and you're trespassing. I need you to leave now. He pulled out his phone and made a call. A few minutes later, Patricia's voice came through his speaker. Mr. Garrett, this survey is necessary for our records. If you interfere, you'll be in violation of additional community standards. Patricia, get your people off my property in the next 5 minutes, or I'm calling the sheriff. You're making this very difficult on yourself. 4 minutes? They left, but not before taking plenty of photos and notes. That evening, I got another violation notice, this time delivered by email. Apparently, I was now in violation for interfering with authorized community activities. Margaret filed a cease and desist order the next day. We also filed a formal complaint with the county about the HOA's boundary expansion, asking for an official review of their claim. That's when things got nasty. I started getting calls from my neighbors, the ones who actually were part of the Cascade Hills development. Most of them I'd never met since the subdivision was on the other side of the main highway. They'd been told I was causing problems for the whole community, that my refusal to comply with standards was going to lower everyone's property values. One caller was particularly hostile. People like you are the reason HOAs exist. You think you can just do whatever you want, make the whole area look trashy. Madam, I run a working cattle ranch that's been here since before you were born. I'm not part of your subdivision. That's not what Patricia said. She told us you were trying to get out of paying your fair share. I started to understand their strategy. They were turning it into a community issue, painting me as the bad guy refusing to be a team player. Never mind that I'd never wanted to be on their team in the first place. The county review moved slowly. Margaret warned me it could take months. In the meantime, the HOA kept up the pressure. They sent someone to photograph my property every few days. They documented every vehicle that came and went. They even started showing up at local town council meetings, complaining about agricultural properties that don't meet community standards. Then, Patricia made a mistake. She gave an interview to the local newspaper about problem properties in the area. She didn't name me specifically, but she described my ranch in enough detail that anyone local would know who she meant, and in that interview she said something crucial. Properties that don't maintain our standards affect the entire community's development plans. We have investors interested in expanding Cascade Hills, but they need assurance that the entire area meets certain criteria. Problem properties can derail millions of dollars in development. Margaret called me as soon as the article published. She just admitted this isn't about community standards or property values for existing residents. It's about clearing the way for development. That supports our argument that any eminent domain threat would be for private benefit, not public use. Is that good for us? It's very good for us. I'm going to subpoena their development plans and investor documents. If we can show this whole thing is about making your property available for their expansion, we've got them. The subpoena triggered an immediate response from Donald Peterson. He filed a motion to quash it, arguing the documents were privileged business information. Margaret counterfiled, arguing they were directly relevant to the HOA's claimed authority and intent. We ended up in court for a hearing on the motion. It was my first time seeing the opposition in an official setting. Patricia sat behind their attorney's table, looking angry. Donald Peterson was exactly what I'd imagined from his voice, middle-aged, expensive suit, the kind of guy who probably charged $500 an hour. Judge Raymond Harrison presided. He was an older man with a reputation for no-nonsense rulings. Margaret argued her case clearly. Your Honor, the defendants have threatened my client with eminent domain proceedings if he doesn't comply with their alleged authority. Understanding their true motivation for targeting his property is essential to our defense. Ms. Brennan's own public statement suggests this is about facilitating private development, not legitimate community standards enforcement, Peterson countered. Your Honor, Ms. Chen is on a fishing expedition. Our business plans have nothing to do with the legitimate enforcement of community standards. Mr. Garrett's property is in violation of properly established HOA rules. The fact that we have development plans for the community at large doesn't change that. Judge Harrison looked at Patricia. Ms. Brennan, did you threaten Mr. Garrett with eminent domain proceedings? Peterson started to answer, but the judge held up his hand. I asked Ms. Brennan. Patricia stood, smoothing her jacket. We informed him of all available options if he continued to refuse compliance. Yes. That's a yes or no question, madam. Yes, Your Honor. We informed him that eminent domain was a possibility. And your HOA has the authority to exercise eminent domain? She hesitated. We believed we could petition the county to exercise it on behalf of community interests. Judge Harrison made a note. The motion to quash is denied. The defendants will produce the requested documents within 30 days. I'm also ordering both parties to return for a hearing on the underlying jurisdiction question in 60 days. If the HOA doesn't actually have jurisdiction over Mr. Garrett's property, none of this is relevant anyway. He looked directly at Patricia. And madam, I suggest you be very careful about threatening eminent domain when you don't have the authority to use it. That could be construed as extortion. We walked out of the courthouse, and I felt like I could breathe for the first time in weeks. That was incredible, I told Margaret. That was just round one, but it was a good round. She smiled. The judge basically told them their eminent domain threat was out of line, and now we get to see exactly what they're planning. The documents arrived 3 weeks later. Margaret spent 2 days reviewing them before calling me in. Nathan, this is even better than I hoped. They have a development agreement with Mountain Vista Properties, a major regional developer. The plan is to expand Cascade Hills by another 300 homes, plus a shopping center and recreational facilities. Your property is right in the middle of Phase 2 of their expansion. She showed me the maps. My ranch sat at what would become the center of their new development, with planned roads cutting right through my grazing land. They've been planning this for 2 years. The HOA boundary expansion was specifically designed to encompass your property and 3 others that would need to be acquired. 2 of those other properties are already owned by Mountain Vista shell companies. They've been buying up the land around me systematically. Your property is the largest holdout. If they can force you out through violations and fines or scare you with eminent domain threats, Mountain Vista gets your land at a reduced price and their development moves forward. That's fraud. It's close. At minimum, it's abuse of process and possibly extortion. The eminent domain threat was definitely over the line legally. Margaret pulled out another document. But here's the real kicker. I found the original HOA boundary expansion filing. It lists the purpose as maintaining aesthetic standards in the existing community. There's no mention of facilitating development. They lied to the county about their intent. Can we use that? We're definitely going to use that. The jurisdiction hearing was scheduled for mid-March. As the date approached, the harassment from the HOA intensified. They started sending daily violation notices for increasingly absurd things. One day, I was in violation because my cattle were improperly colored for the aesthetic standards. Another day, it was because I had mud on my property after a rainstorm. I also started getting strange offers. A real estate agent called, saying she had a serious buyer interested in my property at above market value. When I said I wasn't selling, she pushed hard, saying it was a limited time offer. I asked who the buyer was, and she got evasive. "Let me guess," I said. "Mountain Vista Properties?" She hung up. 2 days before the hearing, someone cut my fence line on the south pasture. 20 head of cattle got out onto the highway. It took me and 3 hired hands 6 hours to round them all up. One cow was hit by a car, not killed, thankfully, but injured badly enough to need a vet. I reported it to the sheriff's department. Deputy Martinez came out to document everything. "You think it was deliberate?" he asked. "The fence was cut cleanly in 3 places. That's not wear and tear." "You have any idea who might do this?" I told him about the whole situation with the HOA. He shook his head. "Damn HOAs. I've seen them cause all kinds of trouble. But property destruction? That's serious. I'll file a report, but without witnesses or evidence, it's going to be hard to prove anything." I called Margaret and told her what happened. "Document everything," she said. "Photos, vet bills, the sheriff's report. If they're escalating to criminal activity, we need a record." The morning of the hearing, I put on the one suit I owned and drove to the courthouse. Margaret met me outside, looking confident. "I've got our presentation ready. We're going to make it very clear that the HOA has no legitimate jurisdiction and that their entire campaign against you is about facilitating private development." The courtroom was more crowded than I expected. Patricia was there with Donald Peterson, plus several other HOA board members I recognized from the photos on their website. I also spotted a couple of guys in expensive suits who had "developer" written all over them. Judge Harrison took the bench promptly at 9. "We're here on the matter of Nathan Garrett versus Cascade Hills Homeowners Association regarding jurisdictional authority. Ms. Chen, you're representing Mr. Garrett?" "Yes, Your Honor." "Then proceed." Margaret stood and approached the bench. "Your Honor, this case is fundamentally about property rights and the limits of HOA authority. Mr. Garrett owns a 200-acre ranch that has been in his family for 4 generations. His deed, dating back to 1947, clearly establishes his property boundaries and rights. Cascade Hills HOA was established in 2019. They claim jurisdiction over Mr. Garrett's property based on a boundary expansion filed in 2023. She submitted a stack of documents. However, as these records show, that boundary expansion was procedurally defective. Montana law requires specific notification procedures and a supermajority vote of existing HOA members. The HOA failed to meet those requirements. Peterson stood. "Your Honor, we followed all applicable procedures." "I'm not done, Mr. Peterson," Margaret said coolly. "Furthermore, even if the expansion had been properly executed, Montana case law is clear that HOAs cannot retroactively impose jurisdiction over properties that predate their establishment without explicit consent from the property owner. In Jacobson versus Pinecrest HOA, the Montana Supreme Court ruled that— "I'm familiar with Jacobson," Judge Harrison interrupted. "Continue." "Mr. Garrett never consented to HOA jurisdiction. His property predates the HOA by 72 years. Under Montana law, specifically MCA 7023-203, an HOA can only claim jurisdiction over properties that were part of the original development or whose owners explicitly agreed to join. Neither applies here." She pulled out more documents. "But the real issue, Your Honor, is the HOA's motivation. Through discovery, we've learned that Cascade Hills has a development agreement with Mountain Vista Properties. Their plan requires acquiring Mr. Garrett's property. The boundary expansion, the violation notices, and particularly the eminent domain threats were all part of a coordinated effort to force Mr. Garrett to sell or abandon his property." Patricia stood up. "That's ridiculous. We're just trying to maintain community standards." Judge Harrison gave her a sharp look. "Ms. Brennan, sit down. You'll have your turn to testify if your attorney calls you." Peterson was on his feet. "Your Honor, our development plans are irrelevant to the question of whether Mr. Garrett's property falls within our jurisdiction." "Actually, they're very relevant," Margaret shot back, "because they show this isn't about legitimate HOA governance. It's about using the HOA as a tool to acquire private property for commercial development. That goes directly to the question of good faith and legitimate authority." She presented the development maps, the timeline of land acquisitions, and Patricia's newspaper interview. "Your Honor, the eminent domain threat is particularly egregious, As this court knows, eminent domain is a government power for public use. An HOA has no such authority. Threatening Mr. Garrett with eminent domain to force compliance with illegitimate jurisdiction is, at minimum, abuse of process. It may rise to the level of extortion. Judge Harrison leaned forward. Mr. Peterson, does your client have eminent domain authority? No, Your Honor, but we could petition the county for what public use? So a private developer can build houses? For community development that would benefit the county through increased tax revenue, and that's not how eminent domain works, Counselor. The judge looked at the documents in front of him. Ms. Chen has cited several relevant cases. Do you have case law supporting your position that an HOA can claim jurisdiction over a pre-existing property without owner consent? Peterson shuffled his papers. Your Honor, the general principle is that HOAs have authority over properties within their boundaries. When those boundaries are properly established and the properties were either part of the original development or agreed to join. Ms. Chen has presented evidence that neither applies here. What's your response? We believe our boundary expansion was valid. Based on what? Ms. Chen presented the procedural requirements under Montana law and evidence that you didn't meet them. Do you have contrary evidence? The silence stretched out. Finally, Peterson said, We'd like to request a continuance to gather additional documentation. Denied. You've had months to prepare. Judge Harrison made notes on his pad. Here's my ruling. Based on the evidence presented, Cascade Hills HOA does not have legitimate jurisdiction over Mr. Garrett's property. The boundary expansion was procedurally defective and cannot be the basis for claiming authority over a property that predates the HOA and whose owner never consented to join. Patricia made a sound of protest, but one of the other board members grabbed her arm. All fines and violations issued by the HOA against Mr. Garrett are void and unenforceable, the judge continued. The HOA is ordered to cease all enforcement activities against Mr. Garrett's property immediately. Furthermore, I'm referring this matter to the county attorney for investigation into whether the eminent domain threat constitutes criminal conduct. Margaret gripped my arm, but I could barely process what was happening. Judge Harrison wasn't done. Ms. Brennan approached the bench. Patricia walked forward, looking pale. Madam, I don't know if you were poorly advised by your attorney or if you simply decided that aggressive tactics would work on Mr. Garrett. Either way, what your organization did here was wrong. You attempted to use legal processes as weapons to force a property owner off land his family has owned for generations, all to benefit a private development deal. It's not what HOAs are for, and it's not going to fly in my courtroom. Your Honor, I'm not interested in excuses. You threatened eminent domain, knowing full well you had no authority to use it. That's serious. If the county attorney determines charges are warranted, you'll be facing them. Understand? Yes, Your Honor. Good. This matter is resolved in favor of Mr. Garrett. Costs are awarded to the plaintiff. He banged his gavel. We're adjourned. I sat there stunned as the courtroom started to clear. Margaret was gathering her papers, looking satisfied. Did we really just win? I asked. We really just won. And Nathan, that bit about referring it to the county attorney? That's significant. The judge thinks they might have committed crimes. Patricia stormed past us without making eye contact. The developer guys were already on their phones, probably reporting the disaster to their bosses. Outside the courthouse, Margaret and I stood in the spring sunshine. What happens now? I asked. Now you go home to your ranch. The HOA can't touch you. All those fines are gone. If they try anything else, we file harassment charges. She smiled. You should be very proud, Nathan. A lot of people would have caved under that pressure. I had a good lawyer. You also had a legitimate claim and the backbone to fight. That matters. Over the next few weeks, things slowly returned to normal. The county attorney did open an investigation into the HOA's conduct. Patricia and 2 other board members were eventually charged with attempted extortion and abuse of process. They took plea deals that included probation and being barred from serving on any HOA boards in Montana for 10 years. Mountain Vista Properties quietly shelved their development plans. Turns out my ranch was critical to their expansion, and without being able to acquire it, the whole project fell apart. They tried to approach me directly about selling, offering way more than the property was worth, but I turned them down. This was my land, my family's legacy. It wasn't for sale. The Cascade Hills HOA itself underwent major changes. Several board members resigned after the scandal. The remaining members brought in new leadership and actually started focusing on legitimate community issues within their actual jurisdiction. I heard they even revised their standards to be more reasonable. I ran into Patricia once, about 6 months after everything ended. I was at the feed store in town, loading bags into my truck, when I saw her in the parking lot. She froze when she spotted me, then looked away quickly and hurried to her car. Part of me wanted to say something, but what was there to say? She'd tried to destroy my life to make money for herself and her developer friends, and it had backfired spectacularly. Justice had been served. Jake came by the ranch one evening in late summer. We sat on the porch with beers, watching the sunset over the mountains. "So you're a local legend now," he said. "The guy who took down the evil HOA." I laughed. "I don't know about legend. I just didn't want to lose my land." "Yeah, but you fought when a lot of people would have given up. That Henderson windmill case I told you about? They eventually settled and agreed to modify it. You went all the way." "I had good motivation, and Margaret Chen is one hell of an attorney." "True that." Jake took a sip of his beer. "You know, there's been talk at the county commission about reforming HOA regulations. Your case got people paying attention to how much power they actually have." "Good. Nobody should go through what I went through." We sat in comfortable silence for a while. The cattle were settled for the night. The barn was solid and red like it had been for decades, and my work trucks sat exactly where they should be on my land, doing their job. "Your grandfather would be proud," Jake said finally. "Yeah, I think he would be." The ranch had been through 4 generations of Garretts, surviving droughts, economic downturns, and the changing times. It had almost been taken by people who saw it as nothing more than an obstacle to their profit margins, but it had survived that too. I thought about everything that had happened: Patricia's first visit with her clipboard and fake smile, the mounting violations, the threats, the stress and uncertainty. Then I thought about Judge Harrison's ruling, the look on Patricia's face when she realized she'd lost, and the feeling of driving back to my ranch, knowing it was safe. Margaret had sent me a final bill that was surprisingly reasonable, considering everything she'd done. I'd paid it gladly, along with a bonus she tried to refuse but eventually accepted. She'd earned it. The local newspaper ran a follow-up story about the case, focusing on property rights and HOA overreach. They interviewed me, and I kept it simple. "This ranch has been in my family since 1947. It's going to stay in my family. That's all there is to it." One unexpected outcome was the number of people who reached out to me after the story ran. Apparently, I wasn't the only one who'd had trouble with aggressive HOAs. Some people were fighting their own battles, while others had already given up and moved or paid massive fines. A few asked for Margaret's contact information, and I gladly provided it. There was one particular call that stood out. An elderly woman named Dorothy called to tell me about her late husband's experience with an HOA in the 1990s. They'd eventually moved rather than fight, and she'd always regretted it. "I'm so glad you stood your ground," she said, her voice emotional. "People need to know they can fight back against this kind of bullying. My Harold would have been cheering for you." Those conversations reinforced why the fight had been worth it. This wasn't just about me and my ranch. It was about the principle that property rights meant something, that bullies with clipboards and threats couldn't just take what wasn't theirs. The investigation into the HOA's conduct revealed even more troubling details. The county attorney found emails between Patricia and Mountain Vista executives discussing how to motivate me to sell. There were references to making life difficult for me, using violations to rack up fines, and the eminent domain threat was explicitly discussed as a scare tactic. When that came out in the local news, public opinion turned completely against the HOA. Several families actually left Cascade Hills development, not wanting to be associated with an organization that had engaged in such conduct. Property values in the subdivision took a hit, ironically achieving the opposite of what Patricia had claimed to be protecting. Donald Peterson, the HOA's attorney, faced disciplinary proceedings from the Montana State Bar. They found that he'd advised the HOA on strategies that were legally questionable at best. He ended up with a suspension and had to take ethics courses before being allowed to practice again. As for my ranch, life went on. I continued raising cattle, fixing fences, and working the land my grandfather had loved. The barn stayed its weathered red. My work trucks parked wherever they needed to be. The dirt driveway remained dirt. I hired 2 additional hands that year because the ranch was doing well. Both of them had heard about the HOA fight and said it was part of why they wanted to work for me. "You stood up for something," one of them said. "That matters." In the fall, I hosted a community barbecue at the ranch, invited all my actual neighbors, the ones who'd been supportive during the fight. Jake came, of course, along with about 50 other people from the ranching and farming community around Billings. We grilled steaks from my own cattle, shared stories, and celebrated the fact that we were all still here, on our own land, living our own lives. Margaret came too, bringing her husband. Over dinner, she told me about another case she'd just taken on another property owner being squeezed by an aggressive HOA. "I've actually been getting a lot of these cases since yours," she said. "I think people are finally starting to fight back. Your case set a good precedent." "Good. Nobody should have to deal with what I dealt with." "Agreed. And now we have Judge Harrison's ruling to cite. It's already been helpful in negotiations." That was satisfying to hear. My fight wasn't just about protecting my ranch anymore. It had become part of a larger pushback against HOA overreach, a legal precedent that would help others. Winter came, as it always does in Montana. The ranch settled into the quieter rhythms of cold weather work. I spent evenings in my grandfather's study, which I'd made my own, going over accounts and planning for spring. One night, I pulled out the old photo albums my grandfather had kept. There were pictures of the ranch from every decade, the original buildings, additions over time, family gatherings, cattle drives. 4 generations of Garrett stared back at me from those photos. I thought about how close it had come to ending. If I'd given in to Patricia's demands, paid the fines, agreed to their standards, it would have been a slow bleed. Eventually, the costs would have mounted to the point where selling seemed like the only option. Mountain Vista would have gotten the land, built their subdivision, and the Garrett Ranch would have been nothing but a footnote in some property records. Instead, it was still here, still working, still home. I added a new photo to the album one Jake had taken at the barbecue. The ranch spread out in the background, the mountains beyond, and me in the foreground with a genuine smile. The caption I wrote underneath was simple: "Still standing, 2025. The county did eventually pass new regulations on HOA, boundary expansions, making the process more rigorous and requiring actual notification of affected property owners. They also clarified that pre-existing properties couldn't be included without explicit owner consent. It was referred to locally as the Garrett Rule, though officially it had some bureaucratic name. I testified at the county commission meeting where they voted on the regulations, kept it brief, just explained what had happened to me and why better protections were needed. "Property rights are the foundation of everything out here," I said. "When an HOA can just decide they have authority over your land, threaten you with fines and legal action, and try to force you out for the benefit of developers, something's broken. These regulations will help fix that." They passed unanimously. Spring arrived again, bringing with it the cycle of ranch work that had repeated for generations. Calving season, fence repairs, preparing the pastures. I threw myself into the work with renewed appreciation. This was mine. Nobody could take it from me with threats and paperwork. I did eventually do some improvements around the property, but on my terms. Repaired some old structures that genuinely needed it, upgraded some equipment, nothing dramatic, nothing that changed the fundamental character of the place. One day in May, almost exactly a year after the whole thing started, I was out mending fence when I saw a car coming up the access road. For a split second, I felt that old tension, who was coming to bother me now. But it was just Margaret, stopping by to deliver some final paperwork related to the case. Everything was officially closed. "I was in the area," she said, getting out of her car. "Thought I'd drop this off in person." We walked up to the house and I made coffee. We sat on the porch, and she looked out over the ranch. "You know, Nathan, I've handled a lot of property cases over the years, some wins, some losses, but this one felt important. It was important, at least to me. No, I mean important in a larger sense. Cases like this remind people why property rights matter, why we can't just let organizations, no matter how official they seem, run roughshod over individuals. She sipped her coffee. You could have given up a dozen times. Most people would have. My grandfather didn't raise a quitter. She smiled. No, I suppose he didn't. After she left, I walked around the property, really looking at it. The old barn, weathered and strong. The pastures where cattle grazed peacefully. The mountains in the distance, eternal and unchanged. The sign at the entrance, Garrett Ranch, established 1947. This was what I'd fought for. Not just the legal principle, not just to win against the HOA. This specific place, this land, this legacy. I thought about Patricia and her clipboard, about Donald Peterson and his smooth threats, about Mountain Vista and their development plans. They'd all underestimated what they were up against. They'd seen an inherited property and assumed I'd be easy to push around. They hadn't counted on stubbornness, good legal help, and the fact that some things aren't for sale at any price. The ranch would go on. Someday maybe I'd have kids of my own to pass it to. Or maybe it would go to a nephew or niece or someone else who'd appreciate what it meant. But it would continue, because that's what it did. It endured. As the sun set that evening, painting the sky in shades of orange and purple, I stood at the fence line and looked back at the house, lights glowing warm in the windows, the barn solid against the darkening sky. Everything exactly as it should be. 4 generations of Garretts had stood in this spot, or spots like it, watching the same sunset over the same mountains. They'd faced their own challenges, harsh weather, economic hardship, the simple grinding difficulty of ranch life. They'd overcome those challenges, kept the place going, passed it down. I'd faced my challenge and overcome it too. The ranch was safe. That was what mattered. I went inside, made dinner, and sat at the old desk to go over the next day's work. Tomorrow the cattle needed to be moved to the north pasture. The week after there was a fence section that needed replacing. In a month, I'd need to arrange for veterinary checks on the herd, normal ranch work. The everyday challenges that were actually challenges, not manufactured violations and legal threats. It felt good. The story could have ended differently. If Judge Harrison had ruled against me, if Margaret hadn't found the evidence she found, if I'd given up when the pressure got intense. The ranch could be a subdivision now, my family's legacy paved over for someone else's profit. But it hadn't ended that way. It had ended with justice, with property rights protected, with a bully held accountable. Late that night, I stood on the porch one more time before bed. The stars were brilliant in the clear Montana sky, the same stars my grandfather had looked at and his father before him. We kept it, I said quietly to the night, to the memory of the family who'd built this place. We kept it. The ranch had survived everything thrown at it for 78 years. Now it had survived one more threat, one more attempt to take what wasn't for sale, and it would be here for 78 more years and beyond. That was my promise to the land, to my family's legacy, and to myself. The Garrett Ranch, established 1947, still standing strong, still home.